Welcome to the second webinar on the Fee to Trust process in 2021. This second session is going to focus more on post-submission NEPA and survey, but we'll also provide participants here with enough time to ask questions, whether in chat or maybe otherwise, but we want to have a really lively discussion throughout this presentation. That said, this is the second webinar in the Fee to Trust series. The third one will be next month. But in between that webinar, which is in the middle of October, and now we have a talk shop with tribal land staff scheduled for October 5th, which is, I think, a Tuesday this time at noon Central. So at the beginning of this session here, when my video goes away, I'll post a registration link to that, and I encourage everyone to save it or register right away. This is a direct link, and you'll get an email about this again too. So if you don't make it to it, that's okay. But that way you just know that October 5th, we have another session where you can talk more directly with some of the professionals we have on the NTLA board. One other piece before I do hand it off. We just saw released this, the Interior is seeking consultations with tribes in different regions on a host of issues relating to fee to trust, rights of way and leasing, sacred and land and treaty rights. And the piece here, and the most important piece, especially for our land staffers and professionals out there listening to us right now, is that you have to attend, you have to register, because this is going to be a Zoom meeting. It's not sponsored with the foundation or NTLA whatsoever. However, we do encourage you to attend and make your voices heard, because you work in these offices and you're the one doing all of this work. It's important that people know who you are and what it is we need to see change to make the programs work more efficiently and promote self-determination. So just for the record, we're going to see in chat go through October 21st for Eastern and Central time zone. We'll have a registration link attached here in the chat box. For Mountain Daylight, we have the 25th of October. So the registration link will be in there. And if you're in Pacific or Mountain Standard, the session will be delivered on 26th of October. However, the link that was sent in the email this morning to everybody was not working. So we will keep you up to date about some of the changes that occur on that end, and relevant material will be posted on the ILTF NTLA website, so that way we have information out there for our professionals. So please stay tuned. We will be in touch. We will talk about these pieces more, and I encourage all of you to participate in these sessions going forward. So without further ado, I will pass on our presentation to NTLA Board Chair Andrew Orozco to begin our session.
All right, thank you, Nichlas. Appreciate that intro, and just want to thank everyone for joining us today. We're excited to bring the second session of the Fee to Trust webinar to you guys, and I think this is a really great opportunity for all of us as land staff, land professionals, to share our experiences, provide an opportunity to answer questions, ask questions. We as board members of NTLA, can speak to, our own experiences with the tribes that we work for and are involved with. But we acknowledge there's many issues that we all face that require a certain level of attention. So, it's a great opportunity for all of us to learn from one another, to share, and to have a dialogue. So with that, we're going to be touching on NEPA and surveying as it relates to Fee to Trust. So with that, we'll start with NEPA and Miss Karen Woodard.
Okay, can everybody hear me?
Yep.
Oh, good. Okay, thank you, Andrew. You might want to go to that next slide, but Karen Woodard, I'm the Realty Administrator for Morongo Band of Mission Indians. I've been with the tribe 22 years. I've put about 2,200 acres into trust for the tribe, including mandatory and individual applications. The information that we're going to go over is mainly from a working knowledge in fee trust, what we've learned over the years, being involved with other tribes, being involved with the California Fee Trust Consortium. So no way am I an expert. Everything is different in different regions, especially when you're doing fee trust. But I just wanted to kind of touch on the different things that would, the NEPA compliance that applies to fee trust. Like I said, I know where I'm not an expert, but I know when to hire an expert. So, so we're just going to touch a little bit on it. Feel free to put questions in the chat room. I'm sorry, I'm dealing with chairman and tribal council stuff today. So you're in my office. Okay, so let's talk about NEPA compliance a little bit. So for the fee trust applications, they're going to be looking at the need, the purpose, and use of the property, which dictates what that environmental assessment will be. So they may be looking at consolidation, economic development, housing, or maybe if it's for cultural purposes that you're purchasing the property. And we can go to the next one. So one of the documents that is a good document for you all to read and review is the Environmental Compliance Memorandum number ECM-10-2. It is on the website. It's on the BIA website. But it talks about federal land transactions or acquisitions. So it looks at pre-acquisition environmental guidance for federal land transactions. It provides guidance and instructions for a federal land manager when acquiring land, and provides protections from environmental liabilities. So they're looking at, is the parcel had any hazardous waste? Has it been a dumping ground? Has it been, previous, airport, or, different types of things like that. They do not want the environmental liability. And Brenda, feel free to jump in anytime because you're also familiar with this. We can go to the next slide.
So I'll just,
yeah, if you want to touch on
going to the next slide, I just want to, so essentially the NEPA compliance for fee trust kind of comes in the way I look at it, two forms. So one is the following through with the phase one assessment, the environmental compliance memorandum that Karen's talking about, which checks, for the hazardous materials. And the other is the NEPA part of it, which looks at at the rest of the environmental issues, and so that's where Karen's saying, you have to see what the project is, what the use of the land is to determine whether you need a CAT X, an EIS, or an EA. Anyway, go ahead, Karen.
Okay. You want to go to the next slide, Andrew? Okay, there we go. So the pre-acquisition environmental assessments are usually conducted in two phases. Phase one is typically involves gathering the information. We'll kind of go into that in a little bit more detail here in a little bit as far as the model report that the BIA environmental staff are preparing for the fee trust application. Phase two, if it's necessary, might involve environmental sampling and analysis by qualified individuals, experienced to evaluate environmental conditions. So say you're purchasing a property, maybe it was, and we did at an old packing plant where it used to pack, it was agricultural site, packed vegetables, might have used pesticides, might have had pesticides stored in the area. So they'll want to kind of dive into that a little bit more and wanting to know, was there any soil contamination? Is there anything that's going to affect, storm water, runoff or groundwater or anything like that? So that's what they're looking for when they get into when we get into a phase two. But phase one is typically the first part of the fee trust process. We can go to the next slide. We'll talk a little bit of that. So the phase one, of course, is the records research. That's your title report, all your easements that are out there, any encumbrances, liens, those types of things. It's going to look at reviewing the maps, the location of it. Photographs, is there anything, if there's historical photographs, if there's current photographs, and any other records that might be relevant to that parcel. They'll also conduct interviews of individuals familiar with the property and its history. They'll look at the site, they'll do a site visit and survey the property themselves. They may walk the entire parcel. They'll visit and they'll inspect it themselves. And we can go to the next one. So what they're trying to do is they're putting together that report, that outline report that they have to, excuse me, I'm just going to turn my phone off. So they have to look at, and they, believe me, they have several worksheets. There's probably 50 pages of worksheets, 60 pages of worksheets that they have to put together. So they're going to put together a summary, the need and the use of the property. So why is the tribe purchasing it? What is the current use of the property? What is the tribe planning to use the property for? They're also going to do an introduction. So that's going to include the purpose and scope and why the environmental review. And we can go to the next one. So then they also get into the site description. So they're going to be looking at the location. They're going to be looking at any legal descriptions available. That's going to be your plat maps, your, parcel maps. Everybody calls them, a different name. So that's why I'm referencing several different ones. You might have an Alta survey of the property, so they'll want to see those documents. They'll look at the site and the vicinity, the general characteristics of it. They'll look at the current use of the property. They'll want descriptions of structures, roads, for access or public use, what other improvements are out there on the site. They'll want to know what type of utilities are out there. Is there water accessible? And it all, a lot of that also depends on what you're going to use the property for. So they'll want to be looking at all of those different types of structures and documents. They'll also want to be looking at the current use of adjoining properties. So if you're going to be doing a project for economic development, they're going to want to look at what that current use is and what's going on with the adjoining properties. Is it in a residential community? Is it, in a commercial area where you can do what your economic development project is? So they'll be looking at those types of uses. And we can go to the next one. I see a lot of chats going on, but so interrupt me if anybody has a question. So they'll also be looking at the user provided information. So that's when we prepare our free to trust application, when we provide them all the title records, the environmental liens, activity that's out there and use limitations. If there's any specialized knowledge that we have of the parcel, commonly known or reasonably ascertainable information they'll be looking at. So if you have documents that are easily accessible, it gives a little bit of history on the parcel. If that's available, provide that. They'll also be looking at if there was any appraisals done on the property, if there's any valuation reductions, if there were environmental issues. So if there was a cleanup, did it devalue the appraised value of that parcel? They'll also be looking at environmental records as far as databases that may have history on the parcel, if there was anything that was a hazardous waste or if there was any records of any type of dumping out there. They'll also want to talk to the owners, property managers. They'll want occupant information if there was anything, if it was a housing development you're buying, or maybe it was an apartment building or something you're buying and maybe you're tearing it down to do something else. They'll want to be talking about that information. They'll also be looking for other reasons for any other assessments. So we'll just make sure you can provide as much information you can when it comes to that NEPA compliance. Go to the next one. And then finally, they give their opinion on the parcel. So they want to, does the initial phase one clear the property of any environmental liabilities, or does it indicate that we need to go a little further? Is there environmental hazards out there? And if there is an environmental hazard, will we have to go into an EA? Do we have to go into an EIS? Do we have to look at, and again, this goes to economic development. If you're doing a project and you're doing a commercial project, the Bureau is going to want to get an environmental assessment on that economic development project. So be prepared for that prior to approving the application under your purpose and need. Or it could be just maybe the property is approved and ready to move forward. If there's no change in use, they can issue the CADX and they can move forward with the application. And we can go on to the next one. So as I said before, not all projects are going to require an EA. Some of them are mandatory acquisitions like fractionated interest and allotments. They're not subject to NEPA. And then, but however, BI staff will want to go out there and physically visit the parcel, even though it's a undivided interest and it's in a 5-acre allotment or 160-acre allotment, they're going to want to physically visit the property. And normally CADXs are issued if there's no change in the use. So if you're providing, your application, you're saying, we're not changing the use of the parcel, then they'll do an environmental overview instead of the EA, which covers the biocultural and the records research. And we can go to the next slide. So I want to kind of touch too on the NEPA tracker system. So this is a new system that the Bureau has implemented, and along with all of the, they're computerizing and, trying to come into the 21st century. The NEPA tracker is a system that used to track all environmental requests, whether it's for leasing, rights of ways, fee to trust. And this is it's for program staff. They look at what the action is. So if it's a fee to trust action, their realty specialist would enter the action to the NEPA tracker, along with the project description, the maps, and any other basic information. And then the environmental staff would confirm what type of environmental approvals are needed and will manage those environmental approvals. So they'll decide if they need additional information. They'll decide if it's going to be an environmental overview or environmental approval, and they'll just manage it from there. It's a system that just it's tracking all of the requests for the environmental. I think that was about all I had on NEPA compliance.
So we had a question, actually a few questions now, hold on. Nathan Jackson, does a statement of proposed use have any effect on future development plans? What happens if we change our mind? So no, I mean, technically, no, you are not bound by what you say you're going to do with the property in either the environmental document or the application, assuming that that it all happens once it's in trust. So they'll put it in trust. Say you think you want housing, and it goes into trust for housing, and then at a later date you decide, what we really want to do is put a farm there. That's perfectly legitimate, and you can do that. BIA tends to not like that so much, because then a lot of opponents of fee to trust, etc., will sort of grab onto those kinds of things, like, well, they said they were going to do this, and instead they built a 60-story casino or something. So but yeah, you can change your mind. I think the other important thing to remember with the NEPA application sort of merge is that you want to make sure that your statement of purpose in the NEPA document, be it the environmental overview or EA, is the same as what you have in your application. Karen, you got anything to add to that?
Nope, I think you covered it.
Okay.
Exactly it. Yeah.
So the next one I think is probably for you. If the tribe owns 50% of the property in trust and they acquire the other 50% of the property in fee, this would fall under the mandatory acquisition ?
And I'm going to say yes.
Okay.
Definitely going to say yes. Doesn't really matter what the current use is, and yes, maybe grazing, but I think it's an undivided interest. The tribe has purchased the remaining interest. So yes, I would say that would fall under the mandatory acquisition.
Okay, great.
And there is a memorandum out there, and it is in the fee to trust handbook on how mandatory acquisitions are processed.
Right. Yeah, and because the fractionated interest mandatory acquisitions are a little different than say something that has to go in with goes in under like a law or a statute or something, congressional act.
Mhm. Correct. Mhm.
And Desiree, yes, mandatory acquisition is the same as the forthwith. It's in.
Yes. Mhm. Yes, it's the same. Okay. Do we want to go on to surveys?
Sure.
Bring Andrew on.
All right, let me change this slide and we can get into survey. All right, thank you, Karen and Brenda. As stated, my name is Andrew Orozco. I am the planning director for the San Pasqual Band of Mission Indians here in Southern California, Pacific region. I am a state licensed land surveyor and also a certified federal surveyor, CFEDS. So, what I want to discuss today, which you see the objectives on the slide there, pertain to fee to trust, but in all reality, surveys and the standards of those surveys that you have done are the same across the board, and they should be the same in terms of standards. So I want to kind of lead with that, because some of what I'll discuss applies to just general land surveying in Indian country. So I hope some of my insight and experience helps one of you or some of you out there in either finding a surveyor or determining which type of survey is needed. So objectives are up, types of surveys. We'll get into best practices and some available resources for those of you out there. Okay. So types of surveys. The official survey, which in terms of BLM and Indian lands held, restricted or in trust, are conducted under the authority of the Chief Cadastral Surveyor, BLM, and are performed by either a BLM surveyor or a CFED surveyor. Those records are what you'll typically find through BLM or the Land Title and Records Office. And for a lot of Indian lands are the original surveys establishing the reservation or ranchos, and then you'll see some subsequent surveys that maybe there was a correction that was required, or some sort of land activity occurred, and a follow-up or subsequent official survey is requested and then performed. These are used in the records that you'll provide with your fee to trust application, and are, an important piece of the historical record. So when it comes to fee to trust, we'll be looking more at local surveys. So we touched on the ALTA survey last webinar, and we talked about what their purpose is. These are probably the highest level of survey you can perform for a couple of reasons. At a high level, this type of survey provides a snapshot in time of the subject parcel that you are looking at. It looks at the boundary, monumentation, potential encroachments. It accounts for all the structures within the boundaries of the parcel. The surveyor is to map out and identify all recorded easements and encumbrances. In addition to that, the surveyor is tasked with identifying potential rights of way or uses, open and notorious uses that are not recorded. That's probably one of the more important components of an ALTA survey, because you're trying to identify anything, any encumbrance that may impact your proposed development. Typically, the ALTA surveys are done when a commercial project is proposed, and these are required by the lenders, but there's several instances where these are required. This type of survey we highly encourage, just because of the thoroughness of it and the standards that are that have been brought forth by lenders, ALTA, American Congress of Survey and Mapping. So now you have consistent standards nationwide on what is required of these surveys. And so when you're dealing with the title companies, when you're dealing with the lenders, this is the most thorough survey that you can provide. The other surveys that are an option, just depending again on your use. You know, if you're doing grazing or you have no change in use, it's always been vacant land. Maybe you just need a survey that's in conformance with the BLM survey manual and applicable state law. That's the minimum requirements, I should say, for any survey, for that matter. And we'll get into pre-qualifying and ensuring that the surveyors that you have out there, that you've employed and are out there on the ground, are looking for and providing due diligence on what's on the ground. Because at the end of the day, their job, our job, is to research the records that are on file, and then go into the field and essentially be an expert witness in identifying, boundary issues and things of that nature. So we'll get into some best practices on the next slide, but the local survey in conformance with the BLM survey manual and applicable state law can be a survey that's applied for lands that you may not have, a heavy use for, and typically are a little bit cheaper. Okay, so now we'll get into best practices, and my intent with this slide is to, again, provide some insight into some of the experiences that I've had working for my tribal government, discussions with our bills and some of our fellow surveyors, and some of the issues that they're seeing with surveys that are performed on Indian lands. And so the goal of this is to really kind of identify and make sure you understand some of the basics in terms of pre-qualification and building those relationships. So in terms of pre-qualification, I always encourage tribes to utilize the CFEDs. The reality is, just as in any other profession, you have great surveyors and you have not so great surveyors. You have surveyors that will do the absolute minimum. You will have surveyors that will literally take the record and not even go out to the site to physically see it, get their boots on the ground. They call those paper surveys. And so those are some of the surveyors that we want to stay away from. Okay. Some of the pre-qualifications that I look at are one, a CFED. That's a great start, because then they have a good knowledge and understanding knowledge of the public land survey system, the PLSS. Just from my experience and going through the CFEDS program, it was really eye-opening to learn really the foundation of how lands were surveyed from the original 13 colonies west, and really understanding that that is the foundation for how lands are subdivided, and it plays a critical piece or critical role in your records research and how you retrace those boundaries. So CFEDS is a great start. Number two, I would look to see, you know, if your surveyor that you're looking at has experience in Indian country. Have you surveyed Indian lands? Have you worked with a tribal community? Have you worked with a tribal government and leadership? As you all know, you know, working with a tribal government and community, it's something that's unlike any other experience that I've had. And there's a learning curve there. A lot of surveyors, a lot of contractors will come in and just get the job done and have no interest in building that relationship. And that's a key component of having a successful, thorough survey within your lands, is if they have experience working with tribal communities. So those are the two primary pre-qualifications. You know, the number one being CFED, I would not skate on that one. I would certainly make sure that at a minimum they're a CFED. And then number two, that can be learned, but I think all of us have enough experience in what we've done to understand who may be problematic out in the field, who may have an issue working within a tribal community. So it's best to filter through that or handle that on the front end. That it'll save you a lot of heartache and provide for a great relationship and product at the end of the day. Relationship. So that's incredibly important. You know, when you hire a surveyor, they have to be willing to speak to the community. They have to be willing to understand that boundaries that are established within Indian country are not always a monument, right? It could have been a handshake. It could have been an agreement that happened generations ago. And so that is all information that is key to a successful survey, and one that the tribe and individuals can support. So I really stress relationships and ensuring that your surveyor has a good rapport with your council or whoever the land staff are that they are working with. And then when they get out in the field, you know, speak with the community while you're out there. You know, you're out there to do a job, but at the same time, you are an extension of the tribal government, number one. And number two, it's going to be in your best interest to, you know, understand and hear the stories or some of the background that could add to your record and final product. Okay. Now we'll get into no shortcuts. So you know, a lot of this stuff crosses over what I'll speak on. You know, no shortcuts. Essentially, what I'd like to discuss is standards. In many of my discussions, you have surveyors who will do the absolute minimum, and furthermore, there's this thought that since you are an Indian country, you're essentially off the radar. Nothing what you do is going to be seen. Get in and get out and make a few bucks. And unfortunately, And this happens in the private sector as well. You know, individuals who are paying for surveys, whether it be a company or tribal government or individuals, are going to look for the cheapest, most economical option there. But that does not mean it's going to be the best product. Okay, and more often than not, the cheapest survey is going to lead to a lot of heartache down the line. Could mean legal fees. It could mean additional surveys that need to take place. So I always recommend ensuring that the surveyor adheres at a minimum to state standards, and additionally the BLM survey manual standards. That doesn't, and so what that equals usually is it's not going to be the cheapest survey. But I promise you, if you go with a surveyor that is going to provide a thorough investigation and can adhere to those standards, you're going to be in good shape. I would recommend, you know, telling the surveyor in advance that regardless of what type of survey they're going to do, that this is going to be recorded, and tell them you're going to record it in the local jurisdiction, right? It's not required that you record at the county or borough or wherever your local jurisdiction is that is the clearinghouse for survey records. But that typically will let them know, okay, well, this is going to see some additional scrutiny, so I better, you know, make sure I'm doing what's right. I would also recommend filing with the Land Title and Records Office. I think that's a good practice and helps not only with future land staff, you know, in the event that we're all gone, it's a record that's forever. But for other surveyors that may be needing the record for an adjoining parcel or a survey that may be related. At a minimum, you know, obviously record it at your tribal office, but there are instances where records mysteriously leave. And so you want to make sure that there's sort of a secondary location for some of these records that you're putting forward. Next, we'll touch on due diligence. And so this is really important when it comes to identifying uses or encroachments, such as, you know, walking paths or roads that may have been used over the years but are not shown on record. Okay, so this is extremely important, specifically with the fee to trust process, because this could lead to future litigation, right? Surveyors, we don't determine whether that is indeed a prescriptive easement or if there's some unwritten right there. We are there to observe and report, right, and make that expert witness. So doing your due diligence, making sure your surveyor understands what you're after, not only from a boundary perspective, but also encroachments and potential unwritten rights. You want to make sure and stress that your surveyor, if he sees it, say something. He's got to get it. He or she has got to get it on the record. That way, that can be addressed on the front end, as opposed to down the road, because it doesn't improve with time, right? So, and then witnesses. This ties back to not only due diligence, but also working with your tribal community. A lot of times, records do not explain the story in full. And so sometimes you have to get a witness statement, and that gets put on the plat. That becomes a part of the record. So you want to make sure that in addition or a part of your due diligence and what your surveyor is doing, he's speaking to those individuals, those adjacent property owners, or anyone who may have a historical background for the subject property. Okay, so at the end of the day, no shortcuts. That doesn't mean the cheapest survey, but at the end of the day, you want to make sure that the survey is complete and thorough. It's going to be in your best interest to do so. Okay. The last item I'll touch on is the land description review, which is a part of the fee to trust process, and as a part of the application. This is a compilation of all of the survey records, and it is a review of the land description, whether that be an aliquot part, being a part of the public land system, lot and block, part of a subdivision, or meets and bounds. So this is an important piece. You want to make sure your surveyor, when you have surveyors performing and providing a legal description, that it ties to the public land system, PLSS, in some way, to a monument or to maybe a local monument that is tied to the PLSS, but make sure that the legal ties to the PLSS. And then the closure report. We all know that the bills have a lot on their plate. And so it's incumbent on us to try and help the situation. And what I mean by that is, a lot of times what we'll do is, rather than just, hey, here's a survey plat and legal description, provide the closure report. That takes a little bit of time off of the bills from actually running the boundary and the legal description. Help the bills out wherever you can, and the closure report helps tremendously. That in addition to developing that rapport with your bills, will allow them to really focus on the closure report instead of this in-depth analysis on the plat and the legal description, and ultimately saves time and allows him or her to get to the other LDRs and issues that they're dealing with. So but those are some best practices. I'd love to hear from the participants and some of our fellow land staff. I know I see a lot of text messages coming through, so we'll see what that includes. But now we'll move on to resources. So, this is something we're going to touch on in every webinar. Some of you know about all these resources and probably can provide some additional resources on their own. But I always like to point individuals to the CFED's website. There's a ton of resources there, not only from locating a CFEDs, but identifying where your bills is. There are BLM standards that you can provide to your surveyor or your land staff to understand some of the minimum requirements. And so go check out that website. Also, your BLM bills, reach out to them and develop a relationship with them. We're at the end of the day, we're in this together, and we want what's best for our community. So if there's any opportunities to help the bills out, or ways that we can streamline some of the projects and surveys that we're doing, they can also answer a lot of questions and give some insight on issues that you may have land related. So developing a relationship with your bills is extremely important. and then local consortiums and working groups. I don't know how this workshop will play out. The third iteration of this Fee to Trust webinar. I think we're going to try and get into maybe some case studies, specific scenarios that we can dive into a little bit. But maybe something comes out of this, as far as developing, some sort of regional work groups that can, bounce ideas and discuss issues. Or maybe we continue this. Maybe this is a webinar that just goes on and on. We in the Pacific region have the benefit of having the Fee to Trust Consortium, which has been around for probably 20, 25 years. I get to see Karen and Brenda there at those meetings. And so this consortium is essentially California tribes who wanted to participate and allocate funds to hiring additional BIA staff to work on Fee to Trust specific related issues and applications, because there was a need there. So the tribes came together, worked with BIA, and put together a consortium that I feel, at least in my opinion and my experience, has been extremely beneficial to understanding some of the issues that are out there and being able to be face to face with the BIA staff that are working on this. So I encourage any of you to utilize these resources. And with that, I think I see 25 text or chat messages. So I think we'll move into the Q&A portion.
Andrew, it's Karen, and we had a question with regards to witness info on the survey. How was actually put it on a plat map when the witness info isn't recorded?
That's just a witness statement and what your conversation was. You would put that on the face of the plat. If I have, and if there's any of my colleagues out there that can add to that, that's typically the practice that I've put forward, but open to any further ideas. But yeah, literally on the face of the plat.
Got some really good suggestions here on our next webinar.
Okay, so let me.
Yeah, so with regard to that, while Andrew's kind of looking through everything, I would say that if you have sort of specific instances or something, some kind of exception or whatever that you've encountered, it would be helpful to maybe shoot stuff into Nick or something, and so that we can take a look at that and see if any of us has ever addressed it. And I guess I should say, since Sarah's not here, I never really introduced myself. My name is Brenda Tomaras. I'm an attorney with many tribes around here. And so just as a disclaimer, I'm participating as a board member, not as an attorney. So anything I say is not considered legal advice. And I'm sure Sarah's going to say the same thing. Anyway, but yeah, so I mean, it would be really helpful for us if you guys have specific exceptions or something, because most of us have run into something at one time or another, and that way we can kind of prepare.
Perfect. Thanks, Brenda. Okay, so I'm trying to get to where we left off.
It looks like we have a hand raised as well. If the board was interested in entertaining some verbal question or comment.
Sure.
Okay,
Of course.
let's see, ask to unmute.
Thank you. Andrew Orozco, licensed land surveyor for Morongo Realty, addressing the note of witness. That's also shown inside your public lands manual for public surveys. But basically what you've done, and I've done this a number of times, is especially in this time where when we're working on Indian land and we have elders out there that again, based on handshakes or things like that, they've come to an understanding of where their property is, whether it's a section line or whatever. But you note the discussion, who you spoke to, and you note it on the plat itself. That way, it's there for future reference, and it is a wonderful tool to utilize, because again, that's what we're trying to do, is we're trying to perpetuate history and understandings, and also the intent of the survey.
Great. Thank you, Andrew Orozco Sr.
Alan Kimbrough, also a bill surveyor, also mentioned that you can put the witness statement in a I'm going to go back to what is noted here, that you can put the witness statement in a diagram, or that can be shown on the plat as well.
So Brianna seems like she knows quite a bit about surveying. I don't know if she wants to just raise her hand and unmute and say a few words or something.
Step up to the podium. We'd love to hear from you.
So while we're waiting for Brianna, we also had a question about where, if somebody, title issues and that, exceptions and that, where can they submit them so that we can take a look at them? Nichlas, could you address that?
Yeah, so if you have any information you'd like to share with the group and with the foundation, with the association, please send them to me. My email address, oops, it is not there. It will be right here. Send it to me at this email address, and we'll make sure that we have this for conversation.
And I guess Brianna's having a hard time unmuting. Did we unmute her?
It's resolved now.
There.
Okay.
Can you hear me?
Yep.
We can hear you.
Thank you. My name is Brianna Joy. I'm a land surveyor in NCFED in Washington State. I would say that the LTA survey is not necessarily something I see a lot happening on Indian ground because of potentially the value of the land, and I think the cost may be really high. But it is something that's very on commercial property, and in that aspect, the surveyor is basically typically providing this information for lenders and people involved in the financing of these large corporate improvements. And so they are basically making that information on the title report very visual by identifying where they are on the ground. So it is a snapshot in time where it is identifying the evidence on the ground of occupation and use, And in that aspect, the part that's really applicable to Indian land country is the idea of it will show if a utility is outside of a described corridor from the document. If they get the complete document, the title status report used to say more about an easement, like saying it was on the east 30 feet of this property, but they have changed their system of recording. And so it's really important that the surveyor be able to obtain the actual documents, because that's where it will actually be described. If the title status report only reveals an easement for a power line 60 feet wide, they're taking a guess. And so they really have to have as much information as the title plants can obtain about an easement. But what they're revealing is if they see a path and they see there may be foot traffic, there may be people that cross while they're doing the mapping that day. And so they may identify, this looks like a pedestrian path that people are using to get through this fishing hole or something like that. So in that aspect, they are revealing potential evidence of an unwritten right, like Andrew has said, but they're not going to be able to say there is a valid right here. They're going to say there's evidence of this, and it's going to be a legal determination if somebody wants to pursue that. But they're basically presenting the records of easements and things, and trying to tie them so that people can visually understand who may have a right there. But as far as if it's expired, if the documents are handed in the title status report or in the actual document that describes the location of an easement, doesn't have an expiration date on it, they wouldn't report that that's expired. They wouldn't report that there's something wrong. I mean, so you would want to have that conversation with your surveyor over how that easement could be invalidated, and how you would want to specifically know that, like if they're outside of that easement, to make sure that they identify the full width of the span of those utility power poles, or to identify the power capacity, whether it's three-phase power, whatever your title documents are actually written to when it's a specific use. The surveyor typically may not take it that far unless they're aware of Indian country and the idea that you are now being very clear to identify piggyback. That's where those extra conversations and getting that surveyor who works in Indian country often can do the best job for you in already knowing many of those things that you're concerned with. Thanks.
Thank you, Brianna. Those are some really good points, and I think just really hammering home the idea that we are essentially surveyors. We're detectives. So it's not, us just out there setting monuments and playing around with GPS. There's a lot of work that goes into, if it's done right, goes into the records research, and so finding a qualified individual that knows where to look beyond the county. It could be forestry, it could be railroad records. I mean, there's a lot of sources out there that pertain to Indian lands, and so finding someone who's going to do the due diligence and find those records, that way they can be that expert witness and provide a good final product for you, I think is incredibly important. So thank you for those comments, Brianna.
We also have a hand raised by Russell Bellamy.
Russell,
Hey, thank you very much. How's it going? Russ with the Osage Nation here. I just had a question, probably, I guess, for Karen. Are there any other circumstances where mandatory acquisition process could be pursued? Or do you have any examples of such?
It's mainly for fractionated interest in allotments.
Well,
Yeah,
sorry,
go ahead.
let me jump in. This is Brenda. You know, when certain lands are placed in through legislation, like when Congress says, you know, we're granting this land, that's considered a mandatory as well, typically.
Well, yeah, the entire, yeah.
Yeah.
It just isn't, the fractionated interests don't require that environmental process. They're not, you know, there's no NEPA compliance.
Right. And typically with the statute, with that kind of mandatory, there's not either. But to you know, to Karen's point, you're not going to see that very often. You're going to, most of the time, you're going to be seeing the fractionated interest, because it's very, very difficult anymore to have Congress put land into trust for tribes.
Okay, thank you. Sorry, I muted myself too quickly after I asked my question. I guess it really pertains to some parcels that were never allotted, and in later years have somehow went into fee simple status. The title never changed hands. One was a property where a railroad was operated, and they were given an easement, but the nation still owns the property now that the railroad is defunct. We were wondering if that would be a potential candidate to try and pursue.
It would probably be under the regular fee to trust process, because normally when I'm talking fractionated interest, usually the remaining parcel is already in trust status. So that's considered a forthwith to bring it into trust. So the parcels you're describing, I think, would probably have to go through the regular fee to trust application process.
Okay, awesome. Thank you very much.
Mhm.
So Sharon Gowdy says, were you going to discuss fee to trust for housing that already exists on non-trust lands within the boundaries of a reservation? You know, if you're going to maintain the housing, then it's going to be a non-change of use. You can get by probably with an environmental overview for the NEPA issues. And then Ross says, I know this is probably a subject for another webinar, but in regards to road rights of way and TSRs, on the TSR, the Act of 2548 is referenced for the road to be constructed by the county. What exactly is that statute? I am not aware of that statute. Andrew or Karen?
I am not either.
Not familiar with that, but we can certainly follow up with you offline,
So
Russ.
Is that the right of way, the original right of way act?
Might be.
Yeah, I think that's the original right of way act. Yeah. So I guess I'm trying to understand the question. The county doesn't necessarily have to construct the road. If the roads are on tribal trust property, you could ask the county to vacate the roads if you want to take over maintenance and owning the roads again. But it looks like you want to know what exactly is the statute. And I believe it was a term on right-of-ways. Recall, Brenda, I think it was a term for 50 years.
Yeah, I'm trying to see if I can find the statute right now. Yeah, that's the original right-of-way statute. So it's now found at 25 USC 323. No, so the if it's an easement, that doesn't mean that they own the road. I mean, so there's fee property, the underlying fee, which is, you know, what the tribe or the nation probably owns. And then the easement that runs across it. So an easement basically is an interest or a ability to use certain property, but not the ownership of property. So if the county's got an easement across that, they have the right to use the easement, but that doesn't mean that they own the land underlying the easement, if that makes any sense.
Correct. And some roads, I believe, were terms of 50 years, others maybe in perpetuity, depending on.
Right.
Yep.
Yeah, and I think now they've gone back to the 50 years.
Yes, they have.
Right,
Yes.
which is good.
Yep.
Okay, I guess I'm the reader of questions. So when the tribe owns multiple parcels of land that are contiguous to each other, is the tribe able to submit one application for all lots if the use will be the same? Typically, yeah. I mean, you know, it's up to the tribe as to, they don't even have to have the same uses necessarily, because you can specify, you know, this is all going to be forest land, but this one right here is going to be a fire department or whatever. So, but yeah, if it's easier for you to do it that way, you certainly are able to do it that way. So Brianna asks, does it refer to the US? Oh, she's talking about the
Yeah, the right-of-way statute.
statute. Yeah.
Yeah, and I believe it did.
It
reference
used to,
that. Yeah,
yeah,
they
it used to be, yeah, that's how it used to be. I don't know if it,
no longer like that, but yes.
right.
We had a question from Margaret Rosenfeld. Also, temporary access permits, they aren't recorded. How do people surveyors track over time? So, you know, ultimately it's one of those things where it's up to the tribe to manage and hopefully have a record of those temporary permits. The next step would be to maybe consolidate them with the use of a surveyor. But you know, they can help in that way and maybe understanding some of the details, but ultimately, because it isn't recorded, it's going to be up to the tribe or individuals to make sure that there's some sort of clearinghouse or repository for these records. Karen, I know you deal with these temporary permits as well. Could you maybe
So
add some recommendations?
yeah, so if we have a economic development project going on and we want, it may take, you know, a few months for to do the actual right of way for that utility. We'll work with the utility company and issue a temporary access permit that allows the utility to come in and do their construction for the utility to provide to our project. Generally, what we do is the temporary access permits is usually tracked by that utility user or that utility, the applicant, as well as the tribe. And then we have 7 years to turn that into the right-of-way process. and get that mapped properly. But yes, the tribe, we generally keep everything in a central location, all of our records. So when we have a surveyor that's coming onto the property that needs to do surveys in that area, we generally have them check in with us. If it's an outside surveyor, fortunately, we have our in-house surveyor now, but generally we'll have them check in with our department, our realty department, so that they can confirm they have all records in that area. So yes, the tribe should track it as well as the utility company.
Don't think we've missed anything so far in the chat.
What other questions or comments do participants have about some of the pieces that we talked about today? We've just been joined by another board member, Sarah Lawson, who has a great deal of expertise in many of the issues that we've been talking about for the past hour and 15. So if you have any questions or comments, you could raise your hand on here and be able to say it verbally or submit it via the chat feature here on the box too. So I just got a message here from Brianna, so I'm going to unmute her. There we go.
Thank you. I appreciate that. Brianna Joy, I wanted to say, going back to that 1948, so what we have is a lot of unrecorded easements, and with the revised regulations, the evidence of an existing easement has been placed on the easement holder. So that is one more reason why the surveyor is not the authority on the validity of an easement that they may show on an ALTA survey or even on a record of survey, is because that may be up to the BIA staff or the tribe to say, yes, I agree. All of the components are there to validate that easement was obtained legally by all the criteria of the law in effect at the time that law was granted. So if that 1948 said that the BIA can approve it without tribal consent, and the easement holder has obtained a copy signed by the Secretary of the Interior, then that may be all the evidence that they feel they need. But the tribe may have a different stance on that. And I don't think that the surveyor is the final opinion. I think that Land Title Records Office or the tribe or the BIA may be that final opinion. So I just wanted to throw that out as caution that a private surveyor that doesn't know Indian law is likely not going to recognize the differences in those federal regulations as far as all those components that define it. So they're just going to be able to visually identify it and map it relative to existing utilities. But it's up to others to make that final determination if that's a valid easement that will be recognized moving forward, or if it's expired, or whatever your other concerns are. So I just want to be real sure that people understand that.
Yes, thank you, Brianna. That's very true. Looks like we've got a couple hands raised here. Andrew Orozco Sr.
Yeah, we as surveyors are licensed as land surveyors, not as attorneys. And it's very important to remember that. If not, you'll have attorneys knocking on your door, giving you a little nice slip of paper to come and visit them, because again, you're practicing law without a law license. So again, just to reiterate, we as land surveyors are showing the intent as shown on title reports, whatever information that we are given. That's all that is what we do, is put onto drawing what is boundaries or whatever. We interpret the easements, we interpret the grant deeds, whatever documents that we are called to be surveying for. That is what we are doing, not to determine if like Brianna said, whether they're valid or not. That's up to attorneys. That's what they get paid the big bucks for.
And then we also have Sarah Lawson. Hi,
Thanks,
Sarah.
Karen. So piggybacking on that, I wanted to quickly say hello, everybody. I'm Sarah Rubidoux Lawson. I'm a member of the NTLA board and an attorney in Seattle, Washington. I'm also going to give my attorney disclaimer where nothing I say here is legal advice. I'm not creating a lawyer-client relationship. I'm not your lawyer. But I can say, speaking from experience, what Brianna and what Andrew Orozco Sr. have said is absolutely correct. So the survey might show that there is an easement on the property, but it's going to be up to the tribal land staff to do some due diligence on that easement and determine if it actually is sort of validly documented and papered, essentially. And speaking to Brianna's point on tribal consent, so tribal consent was required under the federal statutes, starting with a hydroelectric statute in 1935 and then with the General Rights of Way Act in 1948. But some of those prior rights of way, so rights of way granted probably before 1948, did not, the federal statutes did not require tribal consent. Correct. So you're going to want to look at the statutory authority under what those rights of way were granted to determine if under the federal statute, tribal consent was required. And then generally anything after 1948, unless it specifically cites to a statute like the power line statute or the, roads and highways statute of, I don't know, 1901 or 1911. Generally everything after 1948 does have to have tribal consent. So, and then I want to touch on Bill Holloway's point in the chat. I would like to second that encouragement to obtain some property surveys and do some due diligence in that regard prior to acquiring property, because it will help you find these encroachments before you even purchase the property, and you can work those issues out before you even purchase the property. And this has come up very recently in Washington state with the Upper Skagit tribe, where Upper Skagit purchased property. There was a fence line that was over the boundary line. An adjoining owner had a fence that was over the boundary line. The tribe tried to reclaim that land back from the adjoining property owner, and the adjoining property owner said, no, we have a claim to adverse possession here. And so it played out in the courts and the tribe ultimately lost. But in reading that case, all I could think about was, a pound of prevention, or an ounce of prevention is worth a pound of cure. And so if they had done that ounce of prevention by getting an as-built survey done prior to acquiring the property, they would have seen that there was this encroachment on the property and been able to resolve it before they purchased it, resolve it with the seller before they purchased it, instead of fighting it out in the courts and making potentially bad case law later. So.
Thank you, Sarah.
You're welcome. Oh, and I'll happily chime in here too. So the question as to easement extinguishment, Karen's correct. Usually they have an expiration date. There are procedures in the rights of way regulations, 25 CFR Part 169, for extinguishing a right of way that is not in use. Under the old regulations, it used to be that the BIA could extinguish an easement if it had not been in use for 2 years, continuous use for a period of 2 years. I don't remember off the top of my head what the current regulation says. I think there is some provision that is something similar, but definitely look at Part 169 because there are regulations there.
Yes, there are. And there are, it says instances, and I've had this working with one right now, Metropolitan Water District, who has their own tidal plants. And we're trying to extinguish an easement that they had under a FERC ruling many years ago, of which they refused to relinquish, and BIA won't get involved. We've asked them to relinquish it on their end, but they won't. And so we're still working with the Metropolitan Water District trying to eliminate that easement that runs along their aqueduct. But they're not much in favor of doing that. And I don't know if it's because, and this is a question maybe for Sarah and Brenda, under the FERC ruling, because they got it under the FERC ruling, does that easement remain in perpetuity?
You'd have to see what the ruling said, but knowing MWD, it's just that they don't want to give up anything, period.
Yeah, that's kind of what I'm up against.
Yeah, I would definitely look at the ruling. And there might actually be some, since it's FERC, there might be some sort of right of way that might have been granted under that 1935 hydroelectric easement, or I'm sorry, hydroelectric statute, but start with the ruling and go from there.
Thank you.
So Brianna just asked a question in the chat, or didn't really ask a question. Sorry, Brianna, made a statement in the chat about there being more options to resolve issues for land issues under state law, and that's correct. So under state law, there are the remedies of either adverse possession or a prescriptive easement. So prescriptive easement is similar to adverse possession, only it is for roads, basically for roads and rights of ways. But under state law, there are rules for adverse possession or prescriptive easements that would allow these issues with encroachments to be taken care of. Not so much administratively, there is a judicial process that has to be involved, or the landowners can just resolve it amongst themselves and execute an agreement. The problem is once those properties go into trust, so if it's an encroachment on trust land, there is no such thing as adverse possession or a prescriptive easement on trust land. And any remedy is going to have to involve the federal government because the federal government owns fee title to the property. Remember, when that property gets deeded over to the tribe, the deed says the United States of America in trust for the tribe or the individual Indian. So because the United States owns fee simple title, they have to be involved in whatever the remedy is to fixing that encroachment. Yes, and agreed, Scott, about abandonment laws. For example, I'm working on a transaction right now that has an old mining claim on it. And under state law in Washington, you can remove a reservation for minerals that has not been used simply by filing a notice or sending a notice to the individual who purports to own it. And I think you also have to publish in the newspaper of the county where the land is recorded. But there is a process under state law to relieve title of old mineral rights claims. And so, similarly, yes, there are processes under state law that would allow abandoned rights of ways to be dealt with. And as I mentioned earlier, these things get infinitely harder once the property is already in trust. So. Desiree, it could be a quiet title. It's just going to depend on, I think, the nature of the issue that you're dealing with and what remedies are available under state law.
We have a few more minutes if there's another question that someone would like to ask some of our experts here on today's conversation. All right. Well, I have to say that, these sessions are more than just the traditional webinar type. We've opened up to where more of the participants, you sitting out there, can participate in a really meaningful way. And these conversations are more like a working group than they are come and listen to this. And so this has been, I think, really rewarding for myself. And, it's definitely something very meaningful. Before I wrap this up, looks like we have one more question. And I'll read it aloud here for one of the panelists to remark on. Can the tribe prohibit the transfer or sale? Frequent companies get a deal, do nothing, and then try to flip the property rights as an asset.
I'm not aware, this is Karen, I'm not aware of anything that the tribe can do to prohibit a transfer or sale.
So we're talking about it from an individual, right? Because it's a completely different issue if the tribe itself wants to.
I guess if you have several hundred people joining.
Okay. Well, that really brings us up to our time here, and I think I'm going to go ahead and close out our meeting today. I want to thank both the participants who've made this a very rich dialogue and our panelists who have decided to share their expertise with us this morning and this afternoon, wherever you may be located. So, as usual, this will be uploaded to Vimeo and will be dispersed. I'll make sure that everyone has access to the PowerPoint. I do have that already. I just need to put it in online. And then once we get that done, you'll get an evaluation link as well in that same email message, asking for your thoughts, asking for your comments. Of special consideration is the question about future topics. We want to know what it is you want to hear about. What conversations do you want to have as a group? What information can we pull together for you that would benefit you professionally in the work that you're doing? So please do let us know. The talk shop with tribal land staff, October 5th, is going to be on Fee to Trust. I just sent the link in the chat. Click there, register. We look forward to having more conversations with you. Many thanks again to Brenda, Andrew, Sarah, and Karen for participating in today's webinar.